Builder's risk and marine insurance. The process of building a vessel or a floating object involves a series of risks. Both the entity who orders the construction and the shipyard are exposed to considerable losses if a casualty takes place. Accident can occur at any of the construction phases involving people and property and also affecting the environment. This event can happen during construction, at the moment the vessel is launched and while sea trials are executed and even just before delivery to the buyer. Under English law, the process of building a ship under the shipbuilding contract is at the end considered a contract for the sale of goods. Lord Diplock stated, "It seemed well settled by authority that, although a shipbuilding contract is, in form, a contract for the construction of the vessel, it is in law a contract for the sale of goods. Therefore, its provision depend on the Sale of Goods Act 1979. As the shipbuilding contract is an agreement of sale of future good, the vessel, which doesn't exist at the moment of the agreement, it appears impossible to pass property to the buyer before the vessel has been built. This is the principle of the Sale of Goods Act 1979, which states that no property of uncertain good is transferred to the buyer, unless and until the goods are ascertained. Basically, this is the approach by Lord Diplock, as the construction of the vessel hadn't yet commenced and there was nothing physically in present. No materials intended for use had been identified and consequently no property in the good passed on the payment of the first installment. This means that once the vessel is built and delivered, the risk will pass to the buyer. The builder is the party who bears the risk while in construction. Anyway, under the Sale of Goods Act 1979, it is possible to agree otherwise in relation of the holding of the risk. This situation is ratified in the standard shipbuilding contract as the clause 31 of the PIMCO New Build Com. Title and risk of loss of or damage to the vessel shall rest with the builder until exchange of the protocols of delivery and acceptance is effective, immediately upon which title and risk shall pass to the buyer. Under Clause 38 of the PIMCO New Build Con, the builder has the obligation to contract insurance on term no less wide than institute clauses for builder's risk term, including institute war and institute strike clauses. Insurers are also to be reasonably accepted by buyers. The coverage of the insurance is to be contracted from the time of first steel cutting or equivalent, or delivery of buyer suppliers, whichever is earlier, until the vessel is completed, delivered to, and accepted by the buyer. BIMCO is the largest shipping association in the world, representing around 2,200 members and provides standard contract and clauses for the industry. As a good policy, the prospective ship owner can also request the builder to be included as co-assured in the policy, since he may hold an interest in the insured object if, for example, the buyer has supplied equipment for the vessel. The mentioned institute clauses are written in the form of marine policies. Therefore, provision of the Marine Insurance Act 1906 apply. Builders' risk clauses as hull and protection and indemnity clauses are nowadays written as time policies. Sea trials. New Build Con Clause 3 states that the builder's obligation is to design, construct, test, and survey, and deliver the vessel according to applicable laws, rules, regulations, and requirements of the appointed classification society. Tests are fundamental to verify that the vessel is safe to be sent to sea for sea trials. Tests are related to safety system and equipment, communication and navigation system, and equipment, including emergency electrical equipment. Instruction for surveyors issued by the Australian Maritime Safety Authority on 2015 provide the explanation why tests to electrical system are fundamental. The vessel electrical system should be tested to ensure its operation, including verifying the functionality of the vessel emergency electrical supply and emergency switchboard. After the surveyor verifies that the vessel has been isolated from any shore power connection, operational generators, and the main switchboard is isolated to stimulate a power failure, they should check to ensure that all essential system and navigation equipment remain operational. Therefore, mentioned tests will diminish any possibility of blackouts, and if they happen, the solution will be on the emergency electrical supply to allow continued control of the vessel. Under new build con, the buyer's representative has the right to participate in all tests, trials, and inspection, and has total access to the shipyard to verify the construction process, but also the relevant warehouse. Sea trials constitute the end of the building process, and from their result depend the acceptance or rejection of the vessel. These are to be conducted with a representative of the classification society and regulatory authorities. The buyer has the right to be present at such trials and is to be notified by the builder with at least 14 days in advance. The Institute clauses for builders' risk. The Institute clauses for builders' risk (ICFPR) were issued by the Institute of London Underwriters (ILU), and they represent the standard clauses for shipbuilders' risk in the English market. In 1998, the ILU merged with the London Insurance and Reinsurance Market Association (LIRMA), giving birth to a new association known as the International Underwriting Association of London (IUA). The IUA currently holds the copyright of all the Institute clauses, which are published in their website to be reviewed by the public. The Institute clauses for builders' risk include cover for hull and machinery, collision liability, and protection and indemnity. Since the English market standard characteristic is to only insure for denominated perils, again, the builder's risk cover is for all risks, excluding earthquake and volcanic eruption. The cover is also available for damage due to faulty design. Other exclusions are war, strike, malicious acts, and nuclear exclusion. War and strike risks are considered in different institute clauses. Standard cover is available whilst the vessel is on sea trials or delivery, but only with a limit of 250 nautical miles distant from the port or place of construction.